Good afternoon, folks. We're just going to open up the webinar here. We will be starting in a couple of minutes. This is the it is October now, installment of our ongoing series for the new tenant landlord laws that are coming into effect in the new year. So today is about tenant rights and remedies that are changing. So if that is what you're looking for, you are in the right place. And again, we'll get started in a couple minutes. So sit back. We will be applying for CLE credit. Don't have that code yet. We'll get into it more in a little bit. But sit back, relax. We'll get started a little bit after 1:30. Thank you. Hello all. See if folks are still joining in, but just give us another couple of minute or so to let some more folks join. We will be starting shortly after 1:30. We have a lot to get through today. But again, this is the October edition of our webinar series on the new tenant landlord laws that are coming up. And again, we will get started here in just a minute or so. All right, so according to my clock, it is 1:31, so we will go ahead and get started here. Thank you for joining us here today. This is the October installment, as I said before, of our new law series on laws that are impacting tenant landlord, rules here in Minnesota. Today we are being joined by Matt Eichenlaub and myself. We are going to be going over some updates to certain tenant rights and remedies, specifically regarding heat, emergency tenant remedies actions, privacy, and a new way of tenants can end a lease early. So a couple of housekeeping things before we get right into it. In case you're new here, Homeline, we are a nonprofit that serves the entire state of Minnesota. We offer our services for free. So if you are a tenant in Minnesota and you've got questions about your rights as a tenant, then you can give us a call. We also have an email option as well. We are actually, we just we just hit over 310,000 renters. I need to update that just recently. So renter household since our opening in 1992. And this is our contact information. We do offer our services in Spanish, Somali, Hmong, English, and via email. The session is being recorded and it's going to be available on our website in a few days. There is, we encourage questions. We like questions, whether it's about this topic or general tenant landlord questions. We will try and get to those as well if we have time. But please ask those questions in the Q&A function at the bottom of your screen. You can see a little Q&A, little chat boxes at the bottom of your Zoom screen. That is where I would appreciate it if you could put your questions there, because I tend to lose them otherwise. So this is also, we are applying for 1.5 CLE credits. We do not have that code yet. We will get that to the participants after this session is done. But again, 1.5 CLE credits are being applied for. Upcoming webinars. So as I said earlier, this is part of a series. So our next webinar is going to be November 15th. That will cover expungements and evictions. We also have one in December and then also into January with the renter's credit changes. So those are the upcoming webinars that are part of this particular series. Another thing I wanted to mention, just we are having at Homeline a fundraiser next month on November 9th. It's a trivia night at the 9 Mile Brewing in Bloomington, being hosted by Trivia Mafia. Again, this is a fundraiser for us, so wanted to plug that in quick. If that is something that you're interested in, we'd love the support. It should be a fun night. Trivia and dinner is included in the ticket price. So here's our agenda for the day. I want to get right into it because, as you can see, we have a lot to cover. So I'm going to actually transfer it over to our housing attorney, Matt Eigenlob. So Matt, if you want to take it away on our ETRAs.
I sure do. Hi, I'm Matt, and I'm going to talk about ETRAs. The Emergency Tenant Remedy Action is what I'm going to talk about. We call it ETRA for short because Emergency Tenant Remedy Action is a mouthful. So we made some changes at a state level this year. And so whenever we're talking about changes of law, it's always good to start with what was the old law, right? And so the old rule, you could file this emergency tenant remedy action to have the landlord, to essentially bring the landlord to court to ask the judge to order the landlord to make these emergency repairs. We maybe have talked in other webinars about the rent escrow action process, where you send a 14-day letter. Then if it's not fixed, you file the rent escrow, you pay your rent to court, you get a hearing 14 days after filing, right? That's sort of the default process for a tenant to get repairs. That's good, but what if you don't have heat and it's January, right? Do you have to wait the 14 days, then another 14? No, statute sets up this emergency tenant remedy action. So statute set up a bunch of reasons why you can file it. Under the old rule, it was lack of running water, hot water, heat, lack of electricity, lack of sanitary facilities or toilets, and then that sort of other essential services as sort of the situation requires. Those were okay, but a little limited. And so that's the main thing that was changed. The other thing, the district court filing fee is what you would pay to file an emergency tenant remedy action. For a rent escrow, the filing fee was the same or is the same as the conciliation court filing fee. I believe it's $75 or $80, depending on the county. So that was the first change, I think, is changing it from the district court fee now under the new rules to the conciliation court fee. So it is now $75 or $80, depending on your county, to file. So what was the problem? The problem is there's a lot of stuff on here, but it's not everything that could be an emergency, I think. We talked to a lot of tenants, like Rachel said, 310,000 since we started. 10, 12, 15,000 a year recently. It's a lot. And we hear a lot about other emergency repairs that aren't explicitly covered in the ETRA statute. So that was the big bulk of the change, was adding these sort of new causes of action. What are those causes of action? Well, here they are, right? So this is the case of, the first thing is, it's important when the landlord is responsible for providing this service. That's, I think, a key thing, is that it's something the landlord must provide. If it's something the tenant has to provide, that's sort of the tenant's job and theirs to deal with. So when the landlord is responsible for providing it, a non-working refrigerator is now considered an emergency repair issue. Air conditioning, lack of air conditioning, is considered an emergency issue. A non-working elevator is considered an emergency issue. I think, a situation, we can come up with 1,000 exclusions. I'll come back to those, right? A serious infestation, roaches, rats, mice, bed bugs, those are serious infestations. A notice of intent to condemn or a revoked rental license. This is interesting. In the old set of rules, if the city said, tenant, you have to move out because the property is in disrepair, tenant really didn't have much of a remedy. I've certainly advised tenants to file an ETRA, citing sort of the other category here. But now we've got this sort of explicitly, that if the city gives a notice to condemn, the tenant has a cause of action that they can bring. And the loss of any conditions, services, or facilities that pose a serious and negative impact to health and safety. That's, again, sort of the other category, but a little bit more specific in what is other, I guess, right? Just sort of other essential services is awfully vague. These are vague, but in a more specific way, if that makes sense, right? Some more criteria. If you've got some other condition, you've got to show that this is a serious and negative impact, not just other. It's kind of a weird way to think about it. But those are the big changes to the emergency tenant remedy statute. Yeah, let's go to the next slide. So how do you file? So what's the process for filing an emergency tenant remedy action? I think that's important to talk about. I mentioned the escrow a little bit earlier. In that situation, for a non-emergency repair, you'd send a letter, 14 days to repair, and then you'd file the escrow case. This is an emergency. You don't have to wait 2 weeks. This allows you to file after giving a 24-hour notice of repair. That notice can be given voice to voice. It can be left on a voicemail. You can send it, put it in writing. Those are all fine. The next step is to file the petition. The court produces a very good form that you can file. You can download it off their website. It's free. And so that's what I will email to people as the court's ETRA petition. Pay the filing fee. Again, that's not the district court filing fee anymore. Come January 1st, that will be the $75 or $80. You can always ask to have that filing fee waived depending on your income. And then you'll have a hearing. Ideally, the hearing will happen within a few days. Sometimes it is longer than that. Usually there will be a trial set after that hearing. It's unusual that the trial happens the same day of the hearing. And then the judge will issue an order. That order can include an order for repair. That order can include a rent abatement for the tenant, abatement on past and future rents owed. It could require the tenant to pay rent to court. The tenant could ask for the authority to repair the issue and deduct the rent and deduct those costs from the rent, deduct hotel costs if they have to stay in a hotel, those sorts of things. All fair game in these orders. A break lease order could be part of it. The court forms have sort of an other, right? The tenant, the petitioner can ask for other resolutions, other orders as deemed just by the court. So that's good to have. And that's really what you're looking at as far as the court goes. What often happens, right? I talk to a lot of people about this. And so what often happens? To me, I think it's rare that a case is filed. I talk to a lot of people who have these issues, and it's rare that a case is filed. The reason, I think, is because the warning is often enough, is usually enough. This warning that the tenants give, it is something delivered by the phone. and it's usually left on voicemail, and it's something along the lines of, "Hi, my name is Matt. I live at 123 Main Street, and I'm your tenant, and I don't have any heat. You need to fix the heat in 24 hours, or I'm filing an emergency tenant remedy action." That is a that is a mouthful, right? It's a mouthful of legal jargon. It's a very tight deadline. And so a lot of times landlords respond very quickly to that. Also, nobody wants to leave people freezing in the middle of winter. That's not what people want to do. And so a lot of times it's this notice that comes across, and it's very severe and it's very important. And okay, now this is at the top of the list of things to do. And a lot of times that gets a phone call from the landlord, and things get fixed pretty quickly after that. So usually a warning is enough. It usually doesn't go to court because, again, nobody wants to go to court. Nobody wants to leave people in a freezing apartment or a freezing house. That's bad for business because maybe the pipes freeze. Maybe the tenants get desperate and start using the oven as a source of heat, and that's a fire hazard, right? So, for the most part, people don't want to leave other people in emergency situations, and it usually gets resolved after the notice. And
Yeah, I think,
that,
all right. Yep, that. Thank you, Matt. That is what I've got for this section. We do have some questions coming through. Please put them in the Q&A function just so that we can keep track of them. I'm going to now take over here, and we're going to talk about privacy. All right. So another thing that's coming up effective January 1st, 2024, there's going to be two substantial changes to the privacy a tenant's right to privacy. So that is going to be change to subdivision 2, which is entry by the landlord, and change to subdivision 6, which is what the penalty is if the statute is violated. So specifically, entry by landlord. So the changes are that the landlord is going to have the right to enter, but only if they give a minimum of 24-hour notice. There is an exception for emergencies still. And the notice has to include a specific time or window of time that the landlord is going to be there. And that window or that time has to be between the hours of 8 a.m. and 8 p.m. So prior to this, right now, what the law says is that a landlord has to give reasonable notice, and that is not defined anywhere. So some leases, excuse me, will define it as a specific time frame, but there is no definition, like I said, about a reasonable time frame is. So now come January 1st, that time frame is going to be more specifically defined as a minimum of 24-hour notice for a specific time or in a window of time between the hours of 8 a.m. and 8 p.m. So the tenant and the landlord can mutually agree to less than 24 hours. And or a time outside of that 8 a.m. to 8 p.m. window if they choose. But this is kind of, again, the baseline, the minimum of what is the requirement to have for a landlord to have the right to enter. And you still need to have a reasonable business purpose. That part of the statute is not changing, so I didn't really include it in here, but a reasonable business purpose is defined much more definitively under the statute language already, but it's things like maintenance or like a routine inspection, that sort of thing. It's showings if the tenant has given a notice that they're going to be vacating, that sort of thing. So this is the specific language of the new statute, just so that it's really here for more for reference for folks if you want to go back and look into these things. This is what the specific language is. I'm not going to read it to you. I'm sure you all would be asleep in less than 30 seconds. And then the penalty section has also been amended. So currently the penalty is that it's $100 per violation. That was made many, many years ago when $100 meant more than it does now. So at this point, it costs more to file the to file the court case in some instances than it is for the remedy that the tenant would get for a violation of this. So the changes are it removes any the current language says that it has to be a substantial violation. Come January 1st, that substantial language is removed. It's just any violation of the statute. There's no more distinction between the different kinds of violations. It's just, again, a violation of the statute. So it really kind of cleans up that language and makes it much clearer. So you're not looking at, well, is it this or is it that? It's just if it's a violation of the statute, then the penalty is going to be $500 per violation come January 1st. And it allows the tenant to seek reasonable attorney's fees in addition, which is new. And it makes a privacy violation or a violation of the privacy statute a violation of 504B.161. 504B.161 is also the statute that allows a tenant to file a case for repairs that are not emergency repairs. So that's going to be more like a leaky faucet or something like that. So those are all of the changes to the privacy statute as they stand here. So again, a lot of it's more of just clarifying, creating clarity in like the violations of what, if there's a violation, then this is what the remedy is. And it gives, frankly, both landlords and tenants, but specifically tenants, a little bit more clarity in when a landlord is going to be coming to their home and doing stuff. So that is something that has the reasonable notice that is currently on the books is, we can tell you from many, many, many calls, very confusing, and also creates a lot of stress for tenants who don't know exactly when someone is going to be coming into their home, and how many times that we've had folks who literally like, been in the shower when someone comes into their house because, they were, you know, they had to get ready for work or something like that. And so there they are. Or how many people have been talked to who have had someone like come into their bedroom while they're sleeping because, maybe they were not told specifically when someone was going to be coming. And so those sorts of things of people entering their home when they're in especially a more vulnerable condition, like, being in the shower or being asleep in their bed, or, having their kids being asleep in the bed. Those are things that hopefully that will be much, much, much less um, when if with these specific time frame windows and 24-hour notice so that people can prepare. All right. And again, this is the language for the specific statute for subdivision 6 about the penalty, so you can kind of see what was changed. So again, I'm not going to read it to you. You all can come back and reference this. We'll have the slides available on the website along with the recording after this. All right. And then there are no changes to the emergency exception. So if there's an emergency situation, landlords can still enter in. And there's no change to subdivision 5, which talks about entry without a tenant's presence. So what that is saying is that, if a landlord enters and the tenant's not home without prior notice, then the landlord or whomever, maintenance, whomever has the authority to enter, needs to leave a note in a conspicuous location saying that they were there and what they were there for. So violations of those sections, however, are still now treated the same as any other violation of the statute. So that's one of the changes that impact these sections as well. And so what does the landlord need to do to comply? Just kind of a quick overview. So you need to have a reasonable business purpose, like I said, for entry. There is a listing of what those could be, and you need to give the appropriate notice. So starting in January, that's going to be 24 hours with a specific time frame or a window within those 8 to 8 time frame. All right, so that is it for me for privacy. I know we're getting stuff and I want to make sure we get through all of it so that we have time for questions. So I'm going to actually turn it back over to Matt right now, who's going to give us a little bit more detail about heat, which is great because it's getting into winter. So it's a very timely sort of
It's
issue at the moment.
That's right. It's the heat season, which is my favorite 6 months out of the year. But seriously, folks. Okay, so heat. Yes, there were some changes to statute regarding heat rules. The old rule, to say it, was amorphous. it was a hodgepodge of rules, city by city. Each city had their own rule. Some had none at all, and it was really hard to operate and know precisely what the heat code was in each city because each city had a different one. And really, I think about statutes, laws. What we're really looking for is predictability, uniformity, consistency. That's really what we're looking for. Under the old rule, Minneapolis, I think their heat rules went into effect in sort of this like staggered rule where there were some rules in like April, and then they went in, or some rules in September, and then they really kicked in full in October, but then they tapered out in March and April. And some rules it was one temperature all year round. I remember Rochester had a rule that the heat code in Rochester was in effect depending on the temperature at the airport on a given day. And so you had this, when I say hodgepodge, when I say amorphous, it was just, it was all over the place, and nobody knew what was what. We had a database that we always consulted. Um, and in some cities where there wasn't any rule at all, then it sort of defaulted to these covenants of habitability, the duty to keep it fit for the use intended and reasonable repair. What is fit for the use intended when we're talking about the temperature in an apartment or a house? That was the problem. So um, that's the problem we were trying to solve. And this is the solution, the new rule. What it says is a minimum of 68 degrees. Um, the landlord must be able, the furnace, the heat must be able to work at a minimum of 68 degrees. That is effective from October 1st through April 30th. That it must be capable. This is really, it's really fundamentally, it's applicable if the tenant does not control the heat. If the tenant has no control over the heat, then this is what the temperature has to be, is a floor of 68. If the temperature is controlled by the tenant, then they can keep it whatever they want, right? Especially if the tenant is paying the utility bill. Then it's really a question of, well, you've got the control of it. If you want to keep it at 60 degrees in at night and you want to put it at 65 in the day, go ahead, knock yourself out, right? If you want to, you're paying for it, right? If you're paying for it, you want to have it be 78 degrees and have a margarita party, that's your prerogative, right? But if the tenant doesn't have control, then 68 is the floor. And that will be effective, and that rule goes effective January 1st, 2024. So how was this enforced? That's a tricky one, right? I talked about it earlier, the rent escrow, the emergency tenant remedy action. One is for emergencies, one is for non-emergencies. When is heat not an emergency? When is heat an emergency? Right? Like that's a real difficult question to answer. And what I've sort of decided, right, in all my wisdom, is that if the temperature is below 60, I would file an emergency tenant remedy action. That's my advice to people. If it is above 65, if it's in the neighborhood of 65, I would file a regular rent escrow, is how I would approach it. Is that's chilly, but it's not emergency cold. I don't know. That's just my experience, and that's what I tell people. And I think there's could be debate either way. I don't know of a ruling where a judge has said no, 60 is not an emergency, or 61. Look, I haven't heard that feedback. How should a tenant prove their case, right? You can say it's cold, but how should you prove their case? What I recommend is getting data. We have a great video on that. The website for that address is for that video is on the next slide. Here it is. But I recommend getting a thermometer. I've got one right here. I bought this little fella at Home Depot, and it's pretty accurate, and it was less than $5. And it would probably work good in a fridge too if you were worried your fridge wasn't cold enough. And so I recommend using this. Get a notebook, take the temperature in a couple of rooms a couple different times a day, and gather data so that you can go to the judge and say, look, not only does it feel cold, because the judge doesn't care how it feels, right? I can sit in the living room with my wife and I'll be wearing 3 sweaters and she's in a t-shirt, right? It's the same temperature, but it feels differently. So you can say it is cold. I measured it and these are the dates and times and temperatures it was. And that's how you can prove your case as a tenant. Check out the video. A lot of fun making it. You'll see me write down some temperatures. There we go. That's my heat bit.
Awesome. Awesome. Thanks, Matt. I can confirm it's a fun little video. And it goes into a lot of really great information, which even though it was made for the current law as it is still going to be applicable for just some good tips and tricks for how to prove the heat going forward with the new statute as well. So then the I'm going to then finish up with our last topic, which is going to be the ending a lease for infirmity. So this is something that is brand new. Again, it will be going into effect on January 1st, 2024. And it is something that is giving tenants a method for terminating a lease if it becomes medically necessary for them to do so. So there are some very specific definitions that go into here. So I will give you this is what the statute actually says. So again, I'm not going to read it all for you verbatim, but basically it's saying that a tenant or their authorized representative can terminate a lease prior to its expiration if the tenant has had been found by a medical professional to need to move into a medical care facility. And there's some more specific definitions that go into that, such as like requiring assistance with daily living activities or some of the criteria that are listed in other statutes that deal with needing care, need levels of care and disability identification and impairments and things like that. I have linked, or I will go through those. Again, that's going to be on here for your reference purposes. I didn't go into all of the detail for it, but one of the things to keep in mind is that these issues are mostly based off of the right of a tenant that currently has, if there's a death. If the tenant dies, then how an estate can end the lease mid-lease term. So that's kind of what this is based off of, but more with definitions for medical conditions, to be frank, prior to the death of the tenant. So um, there is an exception to this rule. So if a tenant is requiring an accessible unit, and the landlord can provide that accessible unit in the same complex where the tenant currently resides, and that unit is available within 2 months of the tenant making this request or sending in this notice of their intent to end the lease early, then this unit, or excuse me, not this unit, this new statute isn't going to apply. So basically, if say a tenant there's an accident and all of a sudden that they can't access their first level apartment, or it's difficult for them to access their first level, or the up a set of stairs to their apartment, but there's a unit that's coming available next month that is accessible to them for what they need per their medical professional, then the landlord can turn around and say, nope, we don't need to end the lease, we can just move you to this new unit. So that is one of the exceptions to this. So then here's a bunch of definitions again. So authorized representative is a person acting as an attorney in fact. Disability is defined very basically off of the definition that comes with like a reasonable accommodation and reasonable modification. So it's something that a condition or characteristic that impairs or materially limits at least one major life activity. The medical professional, there's been some questions about that, but it is a physician or a registered nurse or a mental health professional. Those are all, as defined under this statute, medical professionals who would be able to say whether the tenant needs this sort of accommodation essentially, or to end their lease early. Medical care facility is a long list of what constitutes that. Again, this is under this statute. So it's things like nursing homes, hospice cares, boarding care, supervised living, accessible units, state facility potentially, foster facility providing foster care for adults, or a facility providing intensive residential treatment services. So these are, again, as defined under the statute specifically for terminating a lease due to infirmity. Um, let's see. So there's some other ones, definitions. These are being pulled from other statutes outside of the Minnesota or tenant landlord statute chapter. This is not the entirety of the chapter of this section, but this is the section that's referenced in the primary part of this new statute. So I wanted to, again, make this available to folks as they were referencing their what meant by uh, nursing facility level care, what was meant by that, the type of care that people need, the type of circumstances that people might be experiencing that would lead them to ending this lease, needing to end their lease due to infirmity. This is another set of circumstances that may present that a tenant would be able to utilize uh, this new statute to, again, end their lease early due to infirmity. So the first set of definitions was all about like the various facilities that people might be having to move into. These last two slides have been about the conditions and the experiences that people may be having that would lead them to need to be able to utilize this statute. Again, this is not the entirety of the section. This is the high level of conditions again. These are not inclusive, but kind of giving us a good baseline of circumstances that might lead a tenant to needing to use this. There is a notice requirement, so the notice has to be in writing. It has to be given at least 2 months before the intended end date, and that end date has to be the end of the month, the last day of the month. The notice either needs to be mailed or hand delivered, and it can be given by the tenant or the tenant's authorized representative. So again, this is drawing some basis off of the existing statute about if a tenant passes away and the estate needs to end the tenancy after that, that also requires a 60-day time frame. So that's where this is coming in from with this 2-month notice requirement. There also needs to include a copy of the medical professional's written documentation of the infirmity and documentation showing that the tenant has been accepted as a resident or has a pending application at a location where the medical professional has indicated that the tenant needs to move. So they need to have that essentially doctor's note, and that they need to show that they have a place that they can go, that they are going to. This is to help mitigate some of the I need to move, but I don't have anywhere to go. And so, the landlord says, okay, we're going to comply with the statute. And so we'll start advertising to rerent your place after this. And then it turns out that the tenant actually can't go there because they weren't accepted or something else falls through. And now they need to stay put. That creates a lot of tension. So trying to avoid that. So the tenant needs to have, proof that they have a place to go, essentially. Tenants are still liable for the rent during that 2-month notice period. So even if they move out, say they move out right away and they give that 60-day notice, they're still liable for the rent during that portion. And it does not impact the use or return of the tenant's security deposit under 504B.178. So basically the security deposit is still the security deposit. It still needs to be returned within 21 days of the tenant vacating and the tenancy ending. But unless there are damages that are above and beyond normal wear and tear. This particular webinar is not about security deposits, so I'm not going to go too much further into that. But the tenant still has the right to their security deposit if they, all the other requirements that are in statute are met, even if they end their lease early under this new statute. And so again, this is our This is all going to be effective on January 1st of 2024, everything we've talked about here. So that is coming up, and here we go. Here's questions. We're going to get to questions, so apologize for that. So then I'm going to start with the questions that were pre-submitted. It's one of the perks about pre-submitting your questions is that we can look at them and we'll get to them first. A lot of them were already kind of talked about. Since I'm asking the questions and it's slightly awkward if I'm also then answering the questions, Matt is going to take point for most of these, unless it's something that I was specifically covering. All right. So, Matt, you ready to go?
I'm ready. This is the fun part.
Yeah, this is great. We're gonna be good. So again, please, if you do have questions that have come up, or you have other things, please use the Q&A function at the bottom of your screen, and we will get to everything that we can. We have a little over 45 minutes, so we should be able to get through hopefully most of this. So please bring them on. Okay, here we go. So Christina is, I believe, a property manager, and they're asking if there are supply chain issues, worker shortages, or any other type of event that might cause delay to repairs. What's the remedy?
Uh, Remedy for who, I guess, right? From a tenant's perspective, the question of supply chain issues or worker shortages, that doesn't necessarily weigh into the equation. Fundamentally, in a landlord-tenant relationship, the landlord promises a place that's fit for the use intended, in reasonable repair, compliant with health and safety ordinances, compliant with statutes. If the furnace goes out and the part is on order, um, that's something that the landlord has to cover, right? If the tenant can't stay in the unit anymore, the landlord promises a place to live, promises a roof over the head, and that's the landlord's burden to pay for that. That's the cost coming from their breach, from their failure to, maybe not failure isn't the right word, right? But from their inability to provide a place that's working like it should, the costs that the tenant takes on are costs that should be paid by the landlord.
Thank you. All right. Next question. Allison is a tenant, and they're talking about tenant's right to break a lease for harassment.
Yeah, I would look at, I think it's 206, 504B 206 talks about the rights of domestic violence victims or victims of particular crimes to break a lease. A lot of times it involves getting an order for protection or no contact order. There are some other sort of qualifying documents that can that allow a tenant to break a lease. Statements from domestic abuse counselor, sexual assault counselor. There's a list in the statute, and so you would use that. It could be. It depends how bad the harassment is, I suppose.
Okay. All right. Next question is from Lori, who's a landlord. How do the heat rules work for rental houses where utilities are paid by renters?
Yeah, the key thing is who has control over the thermostat. If the tenant has control over the thermostat, pays for the utility, that sort of rule about 68 degrees doesn't. The furnace has to be capable of coming up to 68 during the winter, right? Like that's the gist of it. If the tenant decides to keep it at 65, well, that's up to them.
Okay. Deanna, who I believe is a service provider, is asking if a landlord is not repairing items in the rental, how does the tenant set up an escrow and avoid retaliation?
Well, the escrow is the easy one to answer. That's a 14-day letter. We got a great form letter on our website. Send it out, sign it, date it, keep a copy of it for your own records. You know, if it's not done in the 14 days, you can file the escrow paperwork. The court has a really good set of paperwork for that also, and a good set of instructions. You'll get your hearing, and that's what you'll get. The judge will decide at that point, or maybe you'll make a deal with the landlord before the judge gets it. How to avoid retaliation is the difficult question. Retaliation can come in a lot of different forms, and the way the statutes are set up is a little bit complicated. there is this presumption that if a tenant asserts their rights, any negative action taken by the landlord is presumed to be retaliatory for essentially 90 days after the tenant asserts their rights. And so it would be to say, look, this is retaliation. Here's what I did to assert my rights. Here's your action that was retaliatory. It's of no legal effect. Maybe it's a notice to vacate. Maybe it's a rent increase, right? It's of no legal effect, is what you'd say. Again, we got a good form letter on our website. It's worth checking out that deals with retaliation. A complicated issue, and so I could get into it a lot more. I'd love to hear myself talk, and I can really, but those are the steps I would take: is check out our website and our form letters.
I'm posting them in the chat as well.
Just because the landlord does raise the rent doesn't mean it's retaliation, right? It's just a presumption. The landlord has a right to say no. Yeah, I raised your rent, but I raised everybody's rent, and here's proof. It's not retaliatory, right? Certainly, that's something that can happen and does happen.
All right. All right, so this one is probably for me. Anna is a tenant, and they're wondering, does the landlord have to give notice before coming onto the property, even if it's not coming inside? So the privacy statute specifically is about a tenant's right to privacy on the premises rented by the residential tenant is the language that's used. So the premises is, your apartment itself. It doesn't necessarily extend to the curtilage, which is the outside space. It doesn't necessarily extend to the lawn area. Maybe it extends to the backyard. It's some of it is going to be dependent on the circumstances, of course, but where does the tenant have a reasonable expectation of privacy in a rental? Certainly, I think, if you have an apartment, it's where your front door is, into your space. If it's a whole house that you're renting, do you have privacy? Do you have the expectation of privacy in your driveway? Maybe. Do you have expectation in your privacy in the backyard? Probably more so than the driveway, but that gets a little bit more complicated as to, um, where that line is. So I would say that the landlord needs to give notice when they're going to enter the premises that is rented by the residential tenant. So that certainly is going to mean your apartment. They need to give notice that. If they're going to be just on the grounds, they may not need to give notice for that, depending on what the expectation of privacy would be in the particular space that they're entering. I know that's not a very clear answer, but as with many things in the law, sometimes it depends. I'm sorry to say. So Christopher is a tenant, kind of similar to what we had earlier about retaliation. They were just wondering, if the law is not followed, what can tenants do without exacerbating the situation?
I think it's worth it to say that there are, over 500,000 rental households in the state of Minnesota, right? Like there are a lot of renters. We talk to 10, 15,000 people a year. That's a pretty big, pretty wide spread of people, right? But we talk to a lot of people. Most people don't have problems with their landlords, right? Like most of the time, the landlord tenant relationship goes smoothly. Nobody calls Homeline, nobody calls a lawyer and says, hey, everything's going really great. My landlord is great and we're best of friends, right? Nobody calls and says that, right? Or not even best of friends, but we're like fine, right? And so most of the time, I think if you've got a problem and bring it to the landlord's attention, it gets resolved without a problem. Most landlords want to know if there are repair issues because they need to fix them. If there's a leaking faucet or something, a landlord wants to repair that because if they don't, what they're left with is maybe a mold problem that gets worse, right? So it's not always a relationship like this, right? Um, Without exacerbating the situation, I don't know. Obviously, don't yell, um, don't cuss at your landlord, right? Um, I think it's all right to put it in writing, in a way that is straightforward and businesslike, and not shouting on paper is what we used to say with all caps and triple exclamation points and double underlines, right? Um, but I think those are the ways that's how I'd look at it.
All right. Sabrina is a tenant, and I'm just going to answer this one. Sabrina asked about class action lawsuit process. Sabrina, that is potentially an entire day's worth of CLE, explanation in of itself. So that is going to be beyond the scope of what we can cover today, but you can talk to a private attorney or maybe the Attorney General's office is a good place to start with that. All right. Maggie is wondering, can we clarify tenant compensation for maintenance of building regulations of providing housing and employment of a tenant?
Um, a little, not a lot. So this, I think, is sort of the landlord has hired the tenant to be sort of a caretaker role, maybe, is what I'm kind of feeling about it. And that's pretty complicated. What I would want, I guess, is I would want the agreement in writing for starters. Um, I would want specificity, the particular jobs and duties for the particular discount on the rent or payment. Um, it gets into some really tricky situations with what is employment, what makes an employee, what makes an employer. And that shifts into a sort of different area of law that we're really not equipped to answer because employment law and employment contracts, right, are different things than what we know. Um, but the main thing I'd want is specificity about payment and about work expected. That's that's what I would say.
Chris has a question, and I don't know if we need some clarification or not, but what they're saying is, I don't know if it's a change, but what can tenants expect from landlords in regards to tenants who constantly break the lease?
Um, yeah, I read this and I think there's sort of two ways that it could go. Um, if I'm a tenant constantly breaking the lease, I guess I could expect a non-renewal notice. I guess if it's severe enough, I could expect an eviction action filed against me. Um, I think it really matters. When we talk about evictions, we talk about material breaches of the contract, right? Non-payment of rent, someone living there is not on a lease, illegal drugs, illegal firearms, right? Things of that nature, real serious breaches. Um, Notices to vacate, end of the lease, don't want to do business with you anymore, right? Here's your notice to vacate. If you want to include here's why, you certainly can. Um, I guess that's if I was a tenant, that's what I would expect. The other way I was thinking about this is what if I'm a tenant and I'm following the lease and there are a bunch of tenants around me who are constantly breaking the lease, right? What can I expect then? And that's a much more difficult situation when you've got sort of a bunch of neighbors who are causing sort of problems. And I don't have a great answer for that. Oh, second scenario. Okay. That one is going to be ultimately up to the landlord to resolve that problem. The tenant themselves aren't going to have a lot of ability to govern their neighbors because they don't have a contract with their neighbors. It's the landlord who has the contract with the neighbors. And so, ultimately, if there are problem neighbors, it's going to be up to the landlord to resolve those issues.
Otherwise, the tenant has the ability, kind of similar to the landlord, of putting in their own notice that they no longer
Yeah.
want to renew the contract.
Yeah.
Sure.
And we hear that a lot, right? I mean, a tenant is paying the rent on time and, everybody in the building, or it seems like everybody in the building is causing problems and the landlord doesn't want to do anything about it. I mean, or feels they can't do anything about it. It's a real jam to be in, as a
Hmm.
tenant, it's a real jam.
Um, all right. We're gonna move on. Lakeisha is a service provider, and they're wondering if landlords can charge late fees on deposits.
It's a great question.
It's a great question.
One I hadn't thought of. I took a look at the statute and the statute talks about, when a landlord can charge a late fee. And it really only talks about late fees on rent. So I don't think a landlord can charge a late fee on a deposit. Um, at least not under the deposit statute. It gets more complicated. Maybe it would default to the old late fee rule, which is about liquidated damages and reflecting those fees, reflecting potential losses, actual losses because of late payment. Look, I don't want to get into it. Please don't make me get into it. But I don't think they can, is the short answer.
I think a deposit is a deposit and rent is rent.
There we go. See, that's easy. That's simple.
All right. Lisa is wondering, what are the new state laws regarding heat for buildings occupied by nonprofits providing programming or housing?
Same rules.
Hmm.
Yeah, same rules.
Easy enough. Um, what Angela's wondering if there's anything that can be done to report inspectors who are not enforcing repair orders and allowing landlords to lease deficient properties.
That's really tough. Probably I would start with the city, maybe even your city councilor. They're sort of your window to the city and city governance. Um, the other thing would be the rent escrow process allows you to act essentially as your own inspector. I talked about that 14-day letter a lot. There's sort of there are a couple different things you can use to file a rent escrow action, a couple of different ways to notify the landlord of the repairs. One of them certainly is an inspector's report, is that you can call the city inspector, they issue this report, they give the landlord a deadline to fix it. If it's not fixed by the deadline, you can file. But also you can act as your own inspector, and that's the 14-day letter. And so I think you end up acting essentially as your own inspector to file the rent escrow and get your own, at least your own unit repaired.
Okay. And then the last of the pre-submitted questions, I apologize. I don't know exactly how to pronounce this name, but I believe it's Teen or maybe Tina. Um, they're wondering, are there any national landlord tenant coalitions present that they could join? So I'll put in the chat some links to some of the national coalitions that exist. Tenant landlord law is really state specific. So most of the coalitions that exist are state-based and not necessarily national organizations, just as a kind of generality. But again, I'll put some links in the chat here. But now that's the end of our pre-submitted questions. So we'll get into the current ones that came up while we were talking. So Wendy is wondering if the landlord won't fix your broken front door, does that qualify as a serious risk to health and safety?
Uh, it certainly could. I mean, how broken? How broken? Um, I think it. Some of this is sort of what, you know. Look, a door that doesn't lock, right? What good is an exterior door that doesn't lock? That seems like a pretty important thing. Maybe a door that doesn't even close. That's a pretty. If a door that won't close is not a door. That's just an open hole in the wall, right? So yeah, maybe there is an argument for a 24-hour ETRA. Especially with a lock, that's not that complex of a repair, right? And something that could be done pretty quickly, right? Like Menards sells locks, right? Like that's what they do. They sell locks. So yeah, it could be an ETRA. Are we talking about broken as in there's a bunch of scratches on it? I don't think so. That's not going to be an emergency repair.
Okay. All right. Gazan is wondering, they're saying, I thought AC was a luxury and not a necessity.
I mean, even under the old set of statutes, I've certainly advised people to file emergency tenant remedy actions based on lack of air conditioning. In those cases, what I was looking for was usually some sort of, outstanding medical issue, maybe really bad asthma or some sort of heart issue where the doctor's saying, no, you need to have air conditioning because of your health requirements.
Yeah.
Maybe it would be something where the tenant can actually show, look, the apartment is 98 degrees,
Yeah.
right? Like in that
Oh,
situation, maybe it is ETRA worthy.
and I think it's important to point out, Matt, just to clarify,
Yeah.
like this isn't saying that landlords have to provide air conditioning.
Yeah.
Yeah. So like you don't, this is not a building code thing. This is
That's
a,
a really great point. Yeah, that's a really great point. It's not that it's required, but if it's present, right?
yeah.
If it's advertised, if it's present in the building, then yeah, it needs
Yeah.
to work because is it a luxury? Maybe it is, maybe it isn't. I don't know. But
Yeah.
the statute says it's an ETRA.
But if it's there, then it needs to
It's
work,
got to work. Yep.
basically.
That's
So,
what the tenant's paying for.
mhm. Maggie is wondering a little bit of clarification. Can you go over what it looks like when a tenant files for an ETRA when a building is condemned?
Yeah. So this is a little bit sort of new ground because the statute hasn't come into effect yet, right? I have advised tenants to file an ETRA because the building is facing condemnation. Again, sort of fitting it into that, other category under the old rules. A fact pattern that I would recognize, the tenant calls the city and the city comes out and inspects the place and says this place is not livable. you have 14 days to vacate because this place is getting shut down, or maybe 7 days to vacate because it's getting shut down. Sometimes the city will give a list of requirements to the landlord. Here are the 8 or 12 things you need to fix to bring it back up to a habitable level. And if they're not done by this date, then everybody's got to go, right? In that situation, I would tell the tenant to deliver the ETRA notice again, be voicemail, and say, look, you need to make this property livable. You need to resolve the condemnation issues within 24 hours, or I will file an ETRA against you. Now, one thing that we sort of debated around the office, if you get the notice and it's set out, the landlord has 7 days to resolve the issues. Can you give the notice on day one and file on day two with essentially 5 days to go before the notice is up? I don't know. That's awful in the weeds, right? We're awfully in the weeds on that sort of question. But I would say if you've got a condemnation order, it's got a move out date, then homelessness is imminent, and that makes it an emergency.
And yeah, like many things with these new laws, a lot of these things we don't have answers to because the courts haven't weighed in on them yet. So some of this is going to be taking a while to kind of sort out all of the nuances. Heck, there are statutes on the books that have been on the books for decades that we still don't know all the nuances to. So, I mean, take it as it is. We will update everybody as we learn more, I guess.
Yeah.
All right. Sydney is wondering if the fridge breaks on a Saturday, does the landlord need to have a new one installed same day?
This is a really interesting question because it kind of gets into the process of filing, right? Um, I can deliver an emergency tenant remedy action notice on a Saturday, and I've got this like theoretical ability to file it 24 hours later on Sunday, but the courts aren't open, right? Um, need or should, right? If my tenant doesn't have a fridge, when should I provide them with a new fridge, right? Like that's a different sort of question, I guess. Um, I would say the landlord should get them a fridge as soon as they can, right? Some of this depends on availability. Some of this depends on who's out there and what repairs need to be done. But a lot of people rent apartments. And if you've got a building of a certain size, there are probably empty units. And there is probably a working fridge in an empty unit. And so is it that hard to switch them out? Maybe it is, maybe it isn't, right? We can go on Craigslist right now and see if there are refrigerators available. Um, it's sort of a question of how long would you want to be left without a refrigerator sometimes, right? What other steps could be taken, right? I sometimes think about a refrigerator as a giant cooler, right? Maybe it will take a day or two to get a new fridge. Maybe you do have a bunch of food that's left in the refrigerator. Can the landlord provide some coolers? Can the landlord bring over some ice? What can the landlord do so the tenant doesn't lose? Well, we've all been at the grocery store lately, right? We all know how much it costs. Lousy, right? So that's kind of a sort of strange non-answer to a question.
Yeah, fair.
Yeah.
So then let's move on to Andrea's question. Um, I think this is about the privacy one. Is there a reasonable expectation for the window slash time frame given? I'm not 100% certain what that is referring to, like a reasonable expectation of, um, or maybe that's in regards to the ETRA. Maybe we're still in ETRA. I don't know, Andrea, if you've got some clarification as to which topic this is about, that might help clarify some of the answers that we can give. Because for an ETRA, Matt, kind of along the same lines and of what we've been talking about of like reasonable expectation for when the repair gets done, right?
Yeah, there's sort of this, you're not required by law to file the ETRA action on 24 hours and 1 minute, right? If you leave the warning and the landlord seems to be working on it and genuinely is trying to fix the problem, well, good, the system works and you don't have to file, right? It's really, if it's clear it's not getting done, then if it's not done, then it's not done. And not done is not done.
Yep. All right. Um, Sam is wondering, okay, so I think this is for heat specifically. Would time date stamp photos on a phone work as proof also?
Yeah, I think that would be fine. In the video, I talk about writing down in a notebook, the room, the date, the time of day, the temperature, just to have this sort of running tab of dates and temperatures in a way that is digestible, right? In a way that you can show it to a judge and say, look, here it is. Here's what I recorded. And so it's great to be able to say, and I've got the timestamp photos also, right? But part of doing it in a chart and in a notebook is to present it in sort of this like easily digestible information.
Awesome. All right. Maria is wondering, is there any sort of regulation regarding heat for a unit that is too hot?
That's a really great question.
We do get
I
this
think
question.
we do we do get this question. I think it's probably going to be a rent escrow if it's anything. I think it certainly could be too hot, right? Like 98 degrees is really hot. That is extremely hot, especially indoors. Um, I think, could it be an emergency repair? Maybe. You'd have to look at the statute. It talks about, negative effects, right? Um, but yeah, fit for the use intended. If it is 98 degrees in my apartment, I cannot use it how I should. That is not intended to be 98 degrees. Is it fit for the use intended? A reasonable repair? Something might be broken if it's 98 degrees, right? So, uh, yeah, there we go. That's my answer.
All right, done. Anne was asking, I was adding to the broken lock question earlier. I think you talked about that pretty well. Um, Anonymous is wondering, will tenants be able to use the ending lease for infirmity if they're being voluntarily or involuntarily committed? So again, there's a lot of if this then that in that particular statute. And so it is if they have a medical professional saying that they need to move out, and it's to one of those particular facilities for one of the particular reasons that are listed, then yes, it doesn't, then yes, it doesn't matter what it's, if, as long as they can meet all those check marks and give the appropriate notice, and then they can break their lease due to infirmity. So, um, so, voluntarily or involuntarily committed, are they going to one of those facilities? Is their doctor, medical professional, whatever, mental health worker, are they saying that they need to move out and break the lease because of it? And do they have the place that they're going, right? So that's all things that they have to be able to check off in order to be able to break their lease through this particular statute. Okay. Claudia is wondering, does the infirmity statute cover moving in with family for care? Again, it has to be one of those facilities that is listed in the statute. So I do not believe that family constitutes that, but again, you have to dig deeper into those complementary statutes, the ones that are being linked to in it. Like, there's quite the rabbit hole that will go down. This is not going to be like this is not a super easy process, right? This is not going to be someone who's doing this on a whim. This is somebody who's got, serious things that are going on that will necessitate them having to leave and break their lease. So, mhm.
I think it's worth sort of thinking about, what if someone needs to move in with their family members for care and doesn't qualify under the rules to break the lease? What then, right? If the person moves out, they're still liable for rent under the contract, but are they collectible? If they've got 6 months left to go on the contract, they're moving out, they don't pay. As a landlord, what are you going to do, right? Are you going to try to re-rent it, or are you going to leave it empty and see if you can file suit against this person who moved out and is maybe never going to work again, right? Will you collect on that?
Yeah.
So
So,
that's sort of a strange real world practicality. And it's nice. What I like about the statute is that it provides, it ties it up, right? It's not a loose end. If you
mhm,
meet the criteria, it's over and it's
yeah.
done, and you know what it costs you.
Yes,
Moving out, if you have to move out, it's not great. There's a lot of sleepless nights there for a lot of people when they've got a lease sitting out there that's not. So it's a tough situation.
absolutely. And yeah, so yeah, it's if you're moving to a medical facility, unless your family also happens to be a medical facility, probably doesn't count. But all right, Gwen is wondering, does the time frame deal with the exterior of the building? I think this was for the privacy notices and kind of what we were talking about before. For example, lawn spraying is what Gwen says. They don't have to give any notice for that because it's not necessarily entering the premises. It is specifically for the area that you are renting, at least not under the privacy statute. Um, practically speaking, should a landlord warn folks that they're going to be spraying a lawn? Absolutely. I think that's a very good idea just from you know, a communication standpoint. But, for the privacy statute, it's if the landlord or maintenance is entering the premises. Um, and so I don't think that the spraying the lawn would qualify under the statute. If Matt has a different opinion, happy to hear
No,
it.
I think that's good.
Yeah. All right. Moving on. Thank you all. We're doing great. We have a little about 20 minutes left. So thank you all for these great questions. These are great. I'm sorry that if we don't have the most specific of answers, but again, these are new. So, we gotta go with what we have in writing at this point. So Danielle is wondering, when the tenant provides information to end the lease due to infirmity, are there any legal protections requiring the landlord to keep the medical information confidential and not disclose it under to other parties? Uh, there's nothing explicitly in the statute, but I believe that falls under HIPAA stuff, but I could be wrong. I'm not an expert in that. Let me come back to that question. I'm going to go look at the very specific language in this new statute. Um, so we'll come back to that in a minute, Danielle. I think it's a great question, but I don't have a specific answer quite this second. Um, all right, Matt, I'm going to ask you this question, and hopefully you can go off on it for a little bit while I
Well, I sure
go
can.
do some research. Follow up on a question from a property manager. If the furnace fix is delayed because the supply chain issues and the landlord makes every effort to get the heat fixed but isn't able to do so within the day, does the landlord need to pay the cost for the tenant staying somewhere else until the furnace is fixed, such as the hotel? Or is it that the tenant's responsibility to either pay for a place or stay at a friend's or find a friend to stay at?
Yeah, I think it's the landlord's responsibility to pay for housing. This is going to sound probably a little cold, but that's what the tenant pays for, is a place to live with heat. And the law and the statute and probably the lease doesn't say it's the landlord's job to provide a place with heat unless supply chains are messed up. It, that's not the case. It's the landlord's job to deliver a place to live. And if they can't do it for reasons that are outside of their control, that's, again, this sounds really, really coarse and cynical, but that's the gamble that is made when you enter into a landlord tenant contract, is that you'll be able to provide a place that's in good repair, and that the costs of keeping it in good repair will outweigh that the benefits, the rent you collect, will outweigh the cost of repair. That's sort of the nature of the gamble of running a business. And so, yeah, you would be liable to provide alternate housing if the tenant has to go out of pocket to pay a hotel. Yeah, that's going to be the landlord's bill to pay. Um, it's it's what you promise as a landlord, is a place to live and a place that has heat. I'll go on to the next
Yeah.
one. You're reading. I can. I've got the mouse is rolling it. So, does the heat have? Does the heat have to be what the thermostat says, or the actual heat through the whole house? One room heats to 60, but the thermostat is at 68. Thermostat doesn't actually warm to 68. I think what the thermostat says isn't really relevant. The question is, what is the temperature, right? The thermostat could be a good indicator to what is the temperature, but what matters is the temperature. Um, and again, what does fit for the use intended mean? What does reasonable repair mean? To me, it means a furnace that will heat the rooms to the appropriate level. And that means 68 degrees under the statute. Now, is one room 60? Does that make for an ETRA? Probably not. One room being 60 and the rest are 68. Maybe that's only a rent escrow, but that's a question of sort of remedies. But no, 68, 68, and working is working. A property manager, some tenants have been voicing concerns recently. Did you get an answer, Rachel?
I think so. And
Okay,
unfortunately,
I'll
the
let you
answer
go.
is what I had. There's nothing explicitly stated in the statute language that says that the landlord can't share that, but it does, there are references to other laws still apply. It doesn't relieve any rights or remedies that a tenant may have or a landlord may have under other laws. So that is the answer that I've got for that one. Great question, Danielle. Thank you. All right. Do you want to continue on,
Oh, you're
Matt?
doing no. I think this one's yours. This one. Let's see
Okay.
here. Where do we go here? Yeah, I think this one is a privacy one. I think this is for
Okay.
you.
All right. So, property manager and some tenants have been voicing concern recently about their neighbors putting up doorbell cameras in the unit that is next to them, front entries are close to each other. Are there any privacy issues there with the new statute? Should we make the tenants take down the doorbell cameras because it might infringe on their neighbors' privacy? So, the privacy statute is really dependent on like the landlord and their agents entering the premises. Like that's the nuts and bolts of that particular statute. I think as Larry, I believe in the next comment actually is commenting on that. It depends about what the lease says about quiet enjoyment. So, I don't know, Matt, do you want to go? I just stole this one from you a little bit, but
No, no, I don't. No, I didn't have an answer.
okay.
So you did great.
So the whether a ring doorbell or things like that, can a tenant put up a camera that goes into a common area? I think that a landlord can regulate that. Can a tenant have a camera that is in their own unit and things like that? Absolutely, that's their right to do so. Um, the other tenants being concerned about their own privacy and comings and goings, that is a legitimate concern about, whether they have if their lease says anything about that they have the right to their privacy in the common areas or from their neighbors. That usually leases don't necessarily get that detailed, but I think that I think that's going to be ultimately something, as Matt was alluding to earlier, with neighbor issues. Like that's a complicated question, and I think that's one that the landlord is going to ultimately have to decide. But yeah, if the doorbells are in the and the cameras are in the common areas, I mean, does the ring? It's not. Is it constantly running? Is it only when their own doorbell is ringing? Like there's
This is
so
such a
many. Oh,
complicated modern issue, right? This is such a complicated modern issue because like cameras have never been as good or as small or as cheap as they have been ever as they are now. And it sounds like James Bond stuff, right? That we can have these like really great cameras that are just like little itty bitty tiny things, right? And it's going to go to sort of expectations of privacy when you're out in public, right? Like, it's a real mess, and maybe there needs to be a statutory fix to it. But it's going to depend a little bit about what the lease says, what modifications you can do. Oh, it's a thoroughly modern question. Yeah, very much of our times.
um, all right. Wendy is back, and they're asking if you prove that a landlord has retaliated by giving notice at the end of to end the lease, and the landlord still needs to have the right to eventually end the lease. So if the tenant is on a month-to-month lease, how long do you think the landlord would need to wait before giving notice again to avoid any retaliation claims?
That's a really good question, right? You don't have sort of a forever lease just because you ask for repairs. At a certain point, a landlord will have a right to give a tenant a notice to vacate. That's sort of what being a tenant is at its fundamental level, is that at some point the lease is going to be over. The the statute, the retaliation statute is set up in an interesting way. In that first 90 days, it's presumed that a negative action is retaliatory. After the 90 days, it becomes the presumption sort of flips to the other side, that it's presumed that the action is non-retaliatory. Now, the tenant can still show that it's retaliatory. They still have the right to do that, and we can imagine a lot of different ways that they could prove that. Um, so there isn't like a day 91, do what you want, right? Like that's not exactly it, because it could still be retaliatory, right? Landlord says day 91, I'm going to show you now, sucker. Well, okay. I think we got retaliation there, right? But that's not going to happen in real life, of course. Or will it? I don't know. Maybe it has. I don't
Yeah.
know. I've heard from 300,000 people. Probably it has. Um, so this is a tricky thing. I think as a landlord giving a notice to vacate, you want to be able to show why. That if the tenant says, "Hey, this is retaliation," you're able to say, "Well, no, it's not. It's because these reasons, right? You know, yelled at me in my office on 5 separate occasions. You're constantly late with the rent. You've had the police called, 15 times. You threatened other neighbors, right? You're able to say, well, no, like I do have a real business purpose for giving you this notice. And it's because you're a bad tenant."
Okay. I'm going to move us along because we do have, we're running short. We're about 10 minutes in. We got several other questions still. So, Lindley is their case manager, and they just want to make sure that they understand that if they have clients who need to move home because of medical diagnosis from where they are, um, but and losing their job and not being able to afford rent, you're correct. They would not qualify to break their lease under this new statute because it is not moving to a medical facility. So, Don is saying if a tenant submits a work order, does maintenance have to schedule a specific time to enter to complete the work as long as it's within the stated 8 to 8 hours? So this one's mine, I think. And so the specific language again is the notice has to specify a time or anticipated window of time of entry, and the landlord may only enter between 8 a.m. and 8 p.m. unless the landlord and the tenant agree to something different. So it is, you have to, so it should be as specific as possible. All right. Alyssa is saying, is it required to have 2 locks in the front door of a house? Right now the tenant has just a loose deadbolt and they want to either get a knob lock or install it themselves. And some of this is getting a little bit specific. So I think maybe this tenant should give us a call and we can discuss this more
Definitely.
specifically. Because yeah, like at this point yeah, clearly there's a specific issue that is going on that we would be happy to help with. Could talk more into. Um, Lisa is wondering if any package theft and landlords not being concerned, any laws or regs. Uh, Maybe a rent escrow? I think it might be also something to take up with the US Postal Service. Mm,
I don't know. That's a tough one. Secured package delivery is certainly an amenity. That's a good reason to charge more for a property. Um, I don't know. Security cameras have never been cheaper in the history of mankind, I guess also.
yeah. And so similarly, if there's a service being offered, then the landlord has to offer, do that service, do what they promised to do. But if it's just packages are being dropped off and someone else is stealing them, then the landlord isn't responsible for actions of a third party. Tenants really need to file claims with law enforcement and go from there. So this one's about late fees. So tenant owes $67 on $815 of rent. Can a landlord charge a $50 late fee? Late fees are
Eight,
regulated to 8% of what's
um,
owed. What? Sorry, Matt.
nope, that's all right. You had it. You had it. I just, like to hear myself talk.
So what about if the renter or partner passes away? Is there a statute that covers that? And does anyone know of any resources for funeral expenses? Thanks in advance.
I don't know about funeral expenses. Um, there's a statute that deals with terminating the lease on the death of the tenant, but it has to be all tenants. Um, Otherwise, the lease continues if it's just one tenant. One
Um,
tenant remaining, I should say.
yep. And then, sorry, I was looking for that particular statute so I could share it. Um, so, all right, so yeah, Lisa was confirming the HIPAA only applies to medical professionals, but yeah, again, I'm not a HIPAA expert, so other laws do apply, but at least in the statute, there's nothing very specific. But it does look bad if a landlord does share that sort of thing. Mary is wondering, how are we notifying the many folks who are non-English speaking? I'm not 100% certain about which issues in particular Mary is asking about. Oh, and Mary would like to know if we are providing this info in various languages that they can post in their building. So Homeline, specifically, they're asking about Russian, Ukrainian, Ethiopian, and others. Um, so we have our services in Somali, Spanish, and Hmong. So those are the languages that we are able to provide in. We have discussions about we're going to be doing some of these things, kind of an overview in the languages that we do offer. That we have on staffed here. So other particular languages, we don't have the resources to be able to provide that information. Um, you can, there are resources, I believe, available from like the, oh, what's the word? Not the reviser, but the legislature should have some of these resources available in other languages. Um, so that is what I know of for some of these particular rules and regulations and things like that. Is we are happy to provide that information in the language that we have staffed, but we don't have the capacity to do all languages. All right. And then I think that is that, and I feel like we rocked it. So a couple things. Again, we have more webinars coming up covering all of this. New things. We have the December 7th CLE that I had up here. That is going to be covering, that's a full day CLE. It's covering everything. Mark your calendars, saying more information will be coming. And just to get another plug, we have a fundraiser coming up next month. We'd love to see you all there. So thank you all so much for joining us and have a wonderful rest of your day. Take care now and bye-bye.